Friends, we are starting now. Today is 179th Friday group meeting. Our speaker is beloved young Professor James J. Nedumpara. Earlier also he addressed our Friday group meeting, that is the 36th Friday group meeting. The dated is 7/10/2016. The topic was Treaty Interpretation in International Economic Law. So today's topic is India's ICT dispute at the WTO invoking the plea of error in invalidating treaties terms. So very typical subject, but the way he explained in a short note to the Friday group members, I circulated in a short note also. Before you start, I request Saket Gautam will say a few words about our today's speaker, James Nedumpara.
Good afternoon. On behalf of the Friday group and with great pleasure, I welcome Professor Dr. James J. Nedumpara at our Friday group. Professor Dr. James J. Nedumpara is professor and head at the Center for Trade and Investments and the India chair of the WTO chair program. He received his doctorate in law from National Law School, Bangalore, and holds postgraduate degrees in law from the University of Cambridge, National University of Singapore, and the New York School of Law, USA. Thank you.
That's fine? It's fine. Good, good.
So thank you, G.Seshagiri sir. In fact, it is indeed a privilege to come back to this Supreme Court Friday discussion after nearly 7 years. And last time I spoke about something on international economic law and treaty interpretation. My current topic is also not substantially different, but it is more technical. So I'm very happy that this group is actually going from strength to strength, and have been extremely privileged to be part of this. And I've been also, watching some of the videos. It is an extremely good learning experience, and it is actually a very good library. It is a very good digital library for anyone to learn about what is actually happening at the domestic law. So my own topic is, since I have practiced domestic law, but now I'm more of an international lawyer, in the sense that my work is mainly with respect to international law, WTO law, economic law for that matter. So to come back to this case, this is actually a case that went to WTO, but if you really look at the facts of the case, it refers to some of the customs notifications. And India is actually a member of the WTO agreement, where back in 1996, a group of members of the WTO, they decided to reduce the duties on information technology products to zero. So at that time, the sector was actually at its nascent stage. Many countries believed that it is good for everyone to liberalize the duties on ICT products. And there is actually a principle in WTO called the MFN principle. So in reality, only a few countries were actually producing ICT products. And this agreement was a kind of an agreement only among the limited number of countries. But once they joined the WTO, the kind of zero duties which they had negotiated among themselves will have to be extended to everyone in that WTO group. So in a way, everyone, even countries which were not parties to the IT agreement they actually became the beneficiaries of this IT agreement. And the other interesting point is that the IT agreement is not actually an agreement. So I should also tell you a bit of background. The WTO is a big agreement. It has got a number of covered agreements like the GATT, the anti-dumping agreement, customs valuation agreement. It has many agreements for that matter. The the trade-related intellectual property rights for that matter. There are many agreements with respect to that. And the WTO agreement. So these covered agreements will actually become around maybe 600 pages of text. Attached to the covered agreements are basically the scheduler concessions. So that like in every statute, every legislation, you will have a schedule. But in this case, the schedule is actually the list of products in the case of goods, and in the case of services, the various categories of services. So assuming that India wants to take legal services as a committed sector, then within the group of professional services, there will be legal service category, and country can schedule the concessions in the legal services as well. But you know, it is a schedule, it is not the real text of it. But the important point is that these schedules are also an integral part of the agreement. So when a dispute arises, like in a normal case, when we have got a case, we look at the statute or the legislation and try to interpret it. So in the context of these kind of schedules as well, the schedules will have to be interpreted. So what actually happened is that India, there are two, I think, attachments in the ITA schedule. One is actually called attachment A and the other is called attachment B. So in relation to attachment A, you get a number of products, like you can say land phone, an item. So land phone has got a particular thing. Computer is called a ADP, automated data processing machine. It may have a classification called 85, 84 something. So that item is actually there in the schedule. And every country undertakes not to increase the duty above the schedule. So it is actually called the ceiling. So you can't increase the duties above the ceiling. So in this case, this ITA member country, the ITA participants actually took a decision to reduce on 217 items, which are mainly figuring in HS classification number 84 and 85. So there are two chapters. I'm trying to explain a bit more in the sense that every product has got a classification. So now there are nearly 99 chapters in the HS code in the harmonized system of tariff classification. You will actually find it in the customs tariff schedule. So these items are, the items are actually distributed across 99 chapters, and most of the technological products are falling within chapters 84 and 85. So now the issue is, every country actually agreed to lower the rate of duty on these products to zero to facilitate international trade. Now, over a period of time, so again the point is that this classification is based upon a document prepared by the World Customs Organization called the WTO. It is actually an organization based in Brussels. Earlier there was something called a Brussels classification. That was the first classification. The Brussels classification then later on was actually brought within the World Customs Organization, and the World Customs Organization has got various versions of this HS, the harmonized system. So when they negotiated this 1996 ITA agreement, they had to make sure that the products will have to be very carefully listed in the schedule. And what actually happens, the ITA, as I mentioned earlier, is not an agreement, but whatever you undertake under the ITA negotiation was actually brought into your schedule of concessions. So every country, as I mentioned earlier, the WTO text is only 600 pages, but the total WTO agreement is around 26,000 pages, 27, maybe 30,000 pages. And this 21 or 26,000 pages is nothing but the schedules. So schedules are an integral part of the treaty, and with respect to this ITA, all the products which came within this ITA product classification, falling within 84 and 85, were basically translated to or taken to your goods schedule. So now what happened is that, when the ITA negotiation happened, most of you know that nobody had any kind of a cell phone. So most of the people, I don't know, I don't even remember the name of that thing that which people put on their trousers. Pager, right? So these were the things people had at that time. The cell phone technology was actually there, but it wasn't very, very, very popular at that time. It was back in 1996. So a number of products actually, now the point is the very concept of a smartphone came much later. So now we have got in a smartphone multiplicity of technologies. We can actually use it as a computer, we can use it as a camera, we can use it as so there are multi-functionalities attached to some of these technological products. So India has an item. India had actually, so there are a number of items in this particular dispute. One is static converter, pretty complex terms. the other is the base station, then the cell phone for that matter. There are other products as well, which electrical devices and other things, which I don't want to touch upon. Let us actually talk about a very interesting category called cell phone. So at that time, India had undertaken a commitment in a category called 852520. And if you really look at the definition of what is actually 852520, it is transmission apparatus including reception apparatus. So that is actually the description provided in the schedule, transmission apparatus including reception apparatus. Then it also mentions something that, it actually includes radio telephony or radio, I don't exactly remember the term, which is the term?
Radio telephony.
Radio telephony. So radio telephony was a product, was actually the description given in the thing. Years later, there was another HS version. So I mentioned, when countries actually went for the IT agreement, they looked at the 1996 HS version. When the 2002 HS version came, technology really advanced in leaps and bounds. So we have got a number of new products coming in 2002. Then there was another HS version in 2007. There was another in 2012. So HS versions have been coming at periodic intervals. So what happened is that, when the World Customs Organization come up with the new HS classifications, the scheduler concessions will have to be updated. So you have got a category called 852520, which is basically transmission apparatus including reception apparatus. So it can include walkie-talkie, it can include your pager, maybe some of these items for that matter, right? So now in 2002, another kind of HS version came, and then in 2002 one HS version came. In 2007 another HS version came, and the WTO members took a decision to transpose. So what is actually transpose? They want to transpose the 1996 schedule into the 2007 version. It is only updating the version, right? But the important point is that when you update the version, what you agreed in 1996 should not be either expanded or diluted. So there is a principle that when you actually, when you negotiate a treaty, the benefits of the treaty cannot be impaired or nullified. So what you actually agree in 1996 should be preserved going forward, unless you actually amend the treaty provision or go for a rectification or what. So it has to be basically preserved for that matter. So now the issue is, in 2007, there was a decision taken at the WTO in order to transpose this original 1996 ITA commitments into the 2007 HS version. So what happened here is that a large number of complex revisions happened during this particular time. So the very structure of this, this 84 and 85 basically changed. So according to the panel itself, they are mentioning it very clearly that in order to come up with this new HS version or 2007, some of the headings and subheadings had to be actually merged or split. So you split some of the items. So even 852520 has been split into various categories. It was split into 851712, split into 851761, split into 851762. These are the various categories. And in one category, that is actually 851712, there is a mentioning called cellular technology, right? So the point is that there was a mention in the 851712 that it includes cellular technology, because you can either define the product based upon the HS classification, and then you have got the description of the product. In addition to that, if you really look at the Customs Tariff Act, right, there are headings, there are explanatory headings. All these things are actually mentioned. These are basically tools in order to interpret the schedule. So even some of the, if you really want to interpret the harmonized system of tariff classification, there is actually something called general rules of interpretation. So general rules of interpretation can also be used. The basic principle is that one item cannot be classified in two separate categories. If one item is actually classified in two separate categories, what will happen? Then there is no certainty. one country will say that you committed it. The other country will say that, okay, I did not commit in that particular HS heading, I committed in the other one. So in order to avoid that situation, countries are actually, the classification encourages the parties to only use one particular HS system. So now, while coming back to the problem, let us actually look at the elephant in the room. That is basically the cell phone technology, right? India's argument is that, so India later, by 2005, India also realized that India cannot actually become a world leader in information technology, especially in hardware. China had become a leader in this production of these products. India wanted to encourage some kind of a domestic manufacturing as well. But in order to encourage domestic manufacturing, it is always useful to have some kind of a tariff protection for even on domestic producers. And and much later in 2014, India came up with some customs notification. India imposed, I think, 10% duty initially. So when India imposes 10% duty, right, what actually happens? You can argue that this 10% is basically in excess of, it is higher than what you had actually agreed in your schedule or concession. Then the only point of interpretation is, what was the product on which you had actually agreed to keep the customs duty at 0%? So the one argument according to India, it is basically transmission apparatus including reception apparatus, or it includes the radio telephony, where the communication is actually through radio telephony or whatever. So that was the basic understanding at that time. But if you really look at the 2007 HS classification, there is a reference to cell phone. And even in 2002, there was actually one explanation which mentioned cell phone technology. So perhaps the exporters to India, the exporting countries to India can argue that your schedule at the moment, the one that is certified to the WTO, actually contains the item called cell phone, or maybe cellular technology for that matter. And therefore you have made a commitment on cell phone as well, and therefore your 10% of whichever duty is basically a violation of your original commitment. Let us try to understand the problem in greater detail. The transposition process itself is a very detailed process. So as I mentioned earlier, the transposition process is basically based upon a correlation table, right? You have to actually prepare a correlation table. How do you prepare the correlation table? There is a division in the WTO Secretariat called the Market Access Division. The Market Access Division and the WTO Secretariat, with the inputs received from the World Customs Organization, will prepare the correlation table. The correlation table was actually placed before the General Council. So General Council is actually one of the apex decision-making body within the organization. It doesn't have the power to make a treaty, but it has the power to actually take a decision, right? So this correlation table was basically used by all the ITA participants for the purpose of transposing their 1996 commitment into the newer version, which is basically 2007. And so many discussions happen at the General Council and also at the Committee on Market Access. Then ultimately, after 7-8 years, in 2015, India certified the schedule. So the schedule has to be certified, right? India certified the schedule. Then at the same time, the customs actually went on, maintaining this kind of an excess, duty, 10% or 15% on some of these items for that matter. Several WTO members actually raised a concern. They said that this actually belongs to your ITA commitments. India said no. Then I have to bring in something more interesting to you. After ITA had actually concluded, I mentioned that ITA had only 217 products. Then you have got another set of negotiation called ITA 2. So countries including India felt that this ITA 2 is not actually good for India, right? We burned our fingers by joining ITA 1. So why should we join ITA 2? India did not join ITA 2. So one argument is that some of these items are again finding a place in ITA 2. So this is again a very interesting point. Some of the items which the other your counterparts are mentioning to be part of this IT1 are again figuring in the IT2 negotiation. And if the objective of IT2 negotiation is basically to expand the product scope of IT1, then by necessary implication, this product should not have been there in IT1. So that is one argument that India is rightfully justified in making that argument, and that argument was never addressed in a very clear way as well. So now let me come back to the more international elements within that. So what I tried to do in the last 10 minutes was to provide a context to what actually happened. So now think about the possibility. All of you are very senior lawyers. You have actually, assuming that you have certified the schedule. In the schedule, you have got an item called 851712, and that actually pertains to cellular technology, and your bound rate or schedule, bound tariff on that product is actually 0. What can you do? If somebody shows this document on your face, this is the product, this is the rate of duty that you had agreed to, why don't you actually, reduce your applied duty to 0? Very legitimate argument from your exporting partners. But India can say that when we negotiated this agreement way back in 1996, we had no idea about this product. In the sense that we did not give consent. It's actually like a contract. We did not give consent for a 0 duty on this product at all. The WTO might have done some kind of a revision to the HS system. The WTO Secretariat prepared this extremely complex revision by splitting and merging and doing this kind of very complicated exercise. We did not understand it properly. By some mistake, we certified this document, and it is an apparent mistake, right? So we can't. So in the sense that we are actually we are being compelled to, not physically coerced to, but we were made to sign this document not because of our own failure, but because of the failure of the WTO Secretariat in properly flagging the issue when we certified it. So that is actually, that is India's theory, and India raised this thing. Now let me come back to the more interesting issue. The WTO is actually an international agreement. It is a treaty under the Vienna Convention. But WTO is almost like an isolated treaty. There was a huge discussion even in the past whether WTO should be a self-contained regime or WTO should be part of the broader sphere of international law, right? And generally, I think in the initial stages, the approach was to keep the WTO a very unique kind of a treaty, where you do not really borrow public international principles. But in one of the cases, in one of the earlier cases called the gasoline case, the WTO's apex, I won't get tribunal, a judicial decision-making body, said that WTO cannot live in clinical isolation from public international. So they started to actually bring in these kind of public international law elements into WTO law as well. Now the issue is that within the WTO system, there is no explanation of the fundamental principles of law. So we know that once we get into a contract, right, whether the contract was actually concluded by mistake, duress, undue influence, all these things will have to be governed by a different set of law, right? That may be, so you can say the contract is, in India we have got the Contract Act, which basically determines the applicability, the conclusion, the enforceability of contracts. But in the WTO legal system, there is nothing like that. But there is another document called the Vienna Convention on Law and Treaties. So the Vienna Convention on Law and Treaties was actually signed way back in 1969. Interestingly, India is not a party to this treaty. India hasn't ratified this treaty. Neither has many countries, including the United States. But Article 31 through 33 of the Vienna Convention is broadly considered to be part of customary international. And even in the WTO dispute settlement understanding, there is a clear mentioning that the WTO agreements will have to be interpreted in accordance with with customary international principles. And customary international principles will necessarily refer to, it's a broad domain of area, but with respect to interpretation, it will also look to 31 and 32 of the Vienna Convention. So now there is another provision which is actually called Article 48. So the benefit of the audience, I will read this Article 48, which says, A state may invoke an error in a treaty as invalidating its consent to be bound by the treaty if the error relates to a fact or situation which was assumed by the state to exist at the time when the treaty was concluded and formed an essential basis of its consent to be bound by the treaty. So I'll read it once more. A state may invoke an error in a treaty as invalidating its consent to be bound by the treaty if the error relates to a fact or situation. So within inverted commas, fact or situation which was assumed by the state to exist at the time when the treaty was concluded and formed an essential basis of the consent. So India actually took recourse. India invoked. So my talk is actually about invoking the plea of error in invalidating treaty terms. And the treaty term is basically India's commitment with respect to some information technology products like the smartphone and these kind of items. So there are two things. One is actually a fact or situation. During the hearing, the European Union argued that this is not a factual error. This is basically a legal error. And some countries argued that this is neither a factual error nor a legal error. It is a mixed fact and mixed legal. The panel did not really give a conclusive ruling on that point. Perhaps you can argue that the European Union is a legal error in the sense that the schedules are actually part of your treaty, and if there is any kind of error with respect to the schedule per se, it's basically part of the legal thing. But on the other hand, this can also be a factual thing, because India's argument is that we assume certain things, and this assumption was incorrect. And since this assumption is incorrect, that assumption which basically formed the basis of our assent is no more there. And therefore, our schedules should be treated as void. You should not actually look at our schedule. Quite an interesting argument. The panel did not really look into these things, but they made one point which is fairly interesting and perhaps is fairly controversial as well. The panel said that there is something called technological neutrality or technological convergence, for that matter, right? The technology always changes. So when you have given a particular commitment in a treaty, you should assume that your commitment will also evolve with the technology, right? On this particular point, I find it particularly problematic actually. The panel came out with this kind of a feeling based upon the statement of the General Counsel. So the General Counsel basically came up with this decision way back in 2007 for transposition. And in the transposition, what they mentioned is that the technology can change and your commitment can also change. But let me tell you, that's something a bit problematic for many people. Technology may change, but I cannot be committed to a particular agreement unless I had that anticipation in my mind that cell phone, this radio telephony could actually evolve into the cellular technology and maybe something else in the future. Because these treaties are actually meant for eternity. These are perpetual treaties, and technological changes are very fast. So that is why, nowadays I think people are very careful. Many agreements have actually got termination clauses to make sure that, the risk can be contained. So that is again a point which is fairly difficult to believe, but I think the WTO panel actually came out fairly clearly on that point. What they mentioned is that, this is actually in paragraph 7.6. So what they mentioned here is that in this respect we have already concluded about that India is mistaken with respect to the relationship between ITA and its WTO schedule. Specifically, we concluded that as a general rule of product scope of members' tariff concessions contained in the WTO schedules evolves over time to capture products that may come into existence as a result of technological developments, and that this general rule is not changed for certain WTO members by virtue of their participation in IT. This is, I think, a fundamental issue on which there is no consensus whether, because of technology, the commitments will change. There is a very basic principle, as I mentioned earlier, that the terms of the contract cannot change. What you agree today cannot be changed tomorrow to your detriment. Or what they say is that you can't actually, you can't nullify or impair anything. So if India did not want to bring in, India wanted to have a limited product scope and only wanted to include this very narrow category of radio, telephony or whatever, walkie-talkie, India should not be committed into that zero rate for cell phone or other categories of products which may emerge now or maybe in the future for that. On this point, the WTO, this ruling, in my opinion, seems incorrect. But again, it is subject to an appeal proceeding. India can file an appeal. I don't know whether India has filed, but India can file an appeal on this possible issue. The second is actually, the point again, in judicial interpretation again, what they are saying is that it formed an essential basis of India's consent. So what they say is that since you should have known this particular fact, your very assumption is actually incorrect, right? If your assumption is incorrect, then you are unable to invoke the plea of error. That is one thing. Now there is another paragraph which is actually called 48.2. Yeah. So 48.2 says paragraph 1. So paragraph 1 is the legal or factual situation. Sorry, the factual situation. Paragraph 1 of Article 48 shall not apply if the state in question contributed by its own conduct to the error or if the circumstances were such as to put the state on notice of possible error. So when we read this thing, when we read the second paragraph, there are two important things. This first, the provision with respect to mistake will not apply if the state contributed on its own conduct or if the circumstances were such as to put the state on notice of a possible error. So now what the WTO did, the panel did was something very interesting. And this is again, I think all of you know that when it comes to complex adjudicatory matters, the courts won't actually pronounce a verdict. They always sidestep the issue, either not touch upon the issue, or they will take up one area which is easy to decide and then foreclose the decision on a very sensitive matter. So they did not really want to commit very forcefully on whether India made a contribution to its own error. That is, so in WTO matters, in international law, the tribunals are extremely sensitive to the sovereignty. So when sovereign countries actually make a law, they do not want to make attributions about the state's conduct. So the panel has made some comment actually, but it hasn't given a conclusive ruling. But what they say is that the state was actually put on notice. Put on notice of what? Put on notice of a possible error. So a possible error, so that means, again, there is a certain standard of care, a standard of duty on the part of the negotiating countries. That these kind of technological changes can happen in the future when you basically create new revisions or when items are being transposed from an earlier version to a newer version. The state should be very careful. But in India's argument is slightly different. India's argument is that the major, so India in fact hired an international professor called Michael Weibel, who was at the University of Vienna. And this professor actually gave a legal opinion. So professor gave a legal opinion saying that when this whole thing happened, when the transposition happened, when the correlation table was actually made, who was holding the pen? The WTO Secretariat was actually holding the pen. They decided how the splitting and other things should be done. In a way, even the WTO, the whole thing came from WCO. But again, the WTO Market Access Division and the Secretariat had a role in this kind of transposition exercise as well. And there is an obligation actually. So even the panel very clearly says that when really complex transpositions actually happen, there is an obligation on the Secretariat to flag that matter. to flag the matter that this is something very complicated. You are on and I'm putting notice to you. You should study the matter on your own. But again, India is saying that so that this particular tariff lines on which we have got dispute was not properly highlighted. They highlighted certain products. But these particular products were not actually highlighted. Then the second issue is that there were so many meetings. So what the WTO panel report is saying that between 2007 and 2015 there are some 7-8 years, and during this period many discussions actually happened in these committees, right? So you had an option. Your option was to refuse the certification of this document. Why did you certify it? That is the argument the panel is making. So in a way, I think they are actually putting the burden on the country that actually certifies. But again, this is a fairly complex area in the sense that when you actually adjust a treaty, when you update a treaty, it shouldn't really lead to any kind of a new negotiation. Updating, so that's, India has got certain kind of merit in its argument that whatever you do was only to update the whole thing. It did not actually entail making any new kind of a commitment. But what you had done through this correlation process or transposition process was to create new obligations on us. And we hadn't given our assent for that, and our assumption was that the commitments are basically static. Our commitments are static in WTO. Again, this applies to normal contracts as well. In many areas, I think over a period of time things might change, but was the proper consent given by the party? So very interesting dispute. And one important point here, even in international dispute, when you think about the burden of proof, the burden of proof is always on the party that actually asserts a point, right? And many people said that the burden of proof is something like a ping pong. You put the burden on the other side, then it comes back to you, right? So in this case again, if you are actually using an exception, or if you want to completely invalidate a treaty, the burden is on the country that seeks to invalidate the treaty. And according to the WTO panel, India did not actually meet that particular threshold. So the burden is clearly on India. There is another finding on it. These things are fairly common in common law countries, but in international law, at least in the context of WTO, invalidating a treaty based upon a mistake was the first thing. It never happened. In international law, there are a couple of cases. One is actually the Plea of Error case, a temple in Cambodia, right? So it is a very old case between Thailand and Cambodia, and when they looked at the map, Thailand thought that it is actually in Thailand, but it was in Cambodia. But they did not really look at the map carefully, right? So again, the point is that you are actually put on notice. When you have got the opportunity to study the map carefully, and if you did not study it, tomorrow you can't go to the court and say that you invalidate the whole thing, because it was quite difficult for us to understand. But again, my feeling is that this kind of capacity is actually there in developed countries. In developing countries, when treaties are actually negotiated or when this kind of revisions are made, it doesn't really go through the kind of rigorous analysis and exercise. And sometimes you realize the mistake only way too late. So what happened in this case is that India realized the mistake in 2016 and then initiated a process called rectification. So again, there are two ways of actually undoing the damage. The one way of undoing the damage is basically providing a compensation. So then they will really look at the market size for cellular phone, right? It's a huge market, and a 10% difference can make a significant difference to the kind of shares. So if India has to undo the concession, then India has to provide a corresponding compensation, or the other country can actually retaliate against you as well. So there are consequences, in fact. The other is basically when we think about international treaties, there is a provision for rectification. And there is a 1980 procedure. There is a rectification for that. So with respect to rectification again, it has to get the consent of all the parties. So one argument which India made in this case is that India started the rectification procedure in 2017, some countries, and according to India, the rectification was actually very formal in nature, in the sense that it was a matter of formality, and therefore it is not a substantially, I think, a difficult issue. It should have been normally certified, and therefore the panel should not give its ruling when the certification process was actually ongoing. And then India also mentioned that the 1980 certification decision is actually a covered agreement. It's a decision and it is a covered agreement, but the WTO panel said that it is not a covered agreement, in the sense that its legal status is actually much weaker. So although you have initiated a procedure for rectification, the other party brought a case against you. So then what actually happened? Because you already mentioned that you have made a mistake, and based on that mistake, you have sought a rectification. So then it is so easy for the other party, because you have already accepted a mistake. The panel has to only say that, okay, now your schedule actually includes this kind of products. So that is, again, I think in these areas there is no clear provision within the system. Can a party wait until the rectification process is over, or can it be only done after a certain period of time? No particular I think guidance is provided under the existing system. So in order to sum up all these points, it is an interpretative issue as well. And again, one point which I wanted to bring in here, when you really interpret India's commitment, right, whether cell phone or static converter is actually covered by the 1996 IT schedule, which is the schedule that you should use for interpretation? The certified schedule of 2015 or the 1996 schedule? The 1996 schedule has been revised. So the one that is actually in force is 2015 schedule. But the schedule which formed the basis for your consent is the 1996 schedule. But they did not really look at the 1996 schedule. They did not even go into that issue, whether radio telephony will include cellular telephony. All these issues were not even looked at, because the treaty in force is actually the 1996 one. Sorry, to the 2015 one, right? So perhaps India had a bit more merit saying that this technology, this particular product, the radio telephony, has a very limited meaning for that matter. And cellular technology is an entirely new technology. It could not have been captured by the radio telephony technology. So in any case, some of these issues, because of the complexity, did not come up before the panel. But again, I think this case is quite a landmark decision, not because of the difficulty of legal issues, but the way the public international law concept of error or plea of error was actually used in the WTO case. So I will stop here, and I think how many times?
Yeah.
Almost. I will stop here and wait for some of the questions. My colleague Smriti has also worked quite a bit on this matter. So if you want to contribute anything, I will.
Please do that.
I think you mentioned.
Thank you for this wonderful opportunity. And
Sir, I have a question.
Yeah. After that, we'll have a questions. Thank you, James. Last minute catch. Wonderfully, everything is in your fingertips. Really enjoyed your rights. It's a new area. We discuss CPC, criminal, regularly, constitutional. It's a new area, really. It's such a way second time you are explaining to our Friday group member, because it is a new branch. We should have all branch of laws. It's not that a specifically only criminal or civil or a constitutional. It's not like that. We have everything in our we should be up to date. Thank you very much. I'll request Rahul Sharma will give you a vote of thanks. After that, we will have a question answers.
Thank you, sir.
One second.
Yes, sir. Thank you for enlightening us with the international law, especially on this topic related to the World Trade Organization and its dispute settlement mechanism. And I thank G.Seshagiri Rao sir for providing such a resourceful person on this topic. Thank you, sir.
Now you can
Thank
ask.
you, everyone.
Now you can ask question. You remove and stay. Please.
Sir, thank you so much. You have elaborated this topic. As per my short knowledge, last month we have lost the case
Yeah.
before the ICT,
Yes.
right?
Yeah.
And as per my short knowledge also, there is a vacancy of judges also
Yeah.
before the ICT. So would you like to have something on that topic?
Right.
Yeah, what do you suggest, sir? Because I think USA is not willing to appoint the judges
Right.
for the particular state.
So, I didn't actually, it's a good question, but it's slightly different from the topic of my discussion. So, in WTO, it's a very, very active international dispute settlement system with nearly 600 cases. And there is an appellate forum called the appellate body. So, it was functioning very well. It was actually called the crown and the jewel. But because of some of the cases that the United States lost to the WTO, they did not recommend the appointment of members. They don't even want to call them judges actually. So these members were not appointed to the body since December 10, 2019. So for the last 4 years, nearly 3.5 years, I think, 3.5 years, there is no functioning appellate body to hear appeals. So in this case, of course, as I mentioned earlier, India has certain areas where it can appeal. It can definitely appeal in certain areas, but that appeal cannot be heard in the absence of judges. So there is nobody. There is not even one judge. So that decision making, that reform in the appellate body or dispute settlement is going on for a while, and this case can only be heard in appeal once judges have been filled. Yes, that's true.
Please, you enlighten something. You want to? 1 second.
Yeah, please.
Yeah, please.
I think I had a question.
Yeah, you do that, then I will go for it.
Sir, you rightly mentioned that India has not ratified the Vienna Convention of the Law of Treaty, but it has been a member of GATT since 1948 and now WTO since 1995. Sir, do you think that this topic, this error thing, like is fall under the jus cogens principle of international customary law? Though it is like jus cogens is mainly related to the economically like civil and political rights related to, not technology, not related to technology much, but like we follow the principle of national treatment and most favored nation principle in international law. Sir, would this fall under this?
I don't know the exact status of mistake here, because any international treaty can be validated on certain grounds. So now the Vienna Convention clearly provides for it. But I do not know whether it is actually a particular norm in customary international. So in certain areas, just to give an example, to necessity, security measures, most of the agreements have actually provided these provisions, necessity or emergency provisions. But whether it is actually, a jus cogens, I can't, that I don't want to comment upon. I don't think so, because some of the principles are there, but this is definitely, it is part of international law by virtue of codification to an extent. So, if you really look at the state responsibility, the International Law Commission's articles on state responsibility, some of these elements have really been acknowledged. I do not know whether mistake has been that, I'm not sure. Smriti, would you like to add anything?
Yes, maybe it's useful to differentiate between customary international or principles of. So it's useful to differentiate between principles of interpretation and otherwise rules or norms of law that are binding on states independently. So jus cogens or the articles of responsibility of states for internationally wrongful act represent principles of law that are binding on every state by virtue of being a state, regardless of your acceptance of a particular treaty or your joining of a particular body. Compared to that, general principles of interpretation that are codified under the Vienna Convention, principles like the mistake are useful to the extent of interpreting existing commitments that you have formally signed up to under a treaty. In the event of a dispute or in the event anyone wants to really, if there's any question or difference in understanding under a formal agreement. So maybe that is a useful way to differentiate. So they both have legal binding character, but not a general principle of interpretation like a mistake is not binding on you as a state. It is useful in the event of a dispute to come to a conclusion.
So it would not fall under estoppel, principle of estoppel.
It is a general principle of law.
Yeah.
it is a general principle of law. You know, if you have committed a mistake in a treaty making, then you can actually use the defense of general principle of law.
Yes.
It is definitely a source of law under public international law, but its real status is, it is a general principle. It cannot be jurisprudence.
Niti, can you give your introduction, what you are doing?
Yes, I'm Smriti Bhaskar. I'm a senior research fellow at the Center for Trade and Investment Law. I work under Professor James.
Any more questions? Yeah, please.
So is this transposition amounting to novation of contract? Is it borderline novation of contract?
No, it is not actually. You are not replacing anything new. There is nothing new.
Just
There's
correlation.
So it's only updating. So in the case of innovation, there is a new thing, right? The old contract has been replaced by a new contract. But it is not.
I think now we'll wind up. We have a meeting in the auditorium. Close it. We'll take your autograph. Please.